Hello and welcome back to this Safeguarding Children training course. During the course of the lesson, we are going to look at the laws, acts and regulations that govern the action of child protective services in the United Kingdom. In addition to that, we will also explore some landmark incidents and some of the history of child protection. We have a lot to cover, so let's get started. If you have knowledge of modern civil history, you may not be surprised to learn that there were no real protection laws or public movements for safeguarding children in the UK until the late 19th century. Up until then, child labour was seen as acceptable, discipline was harsh, family privacy was expected, and neglect was rife. Legislation to prosecute people who practiced child cruelty only appeared in the 1880s, which started a public reform. The first child protection laws were not specifically designed to stop the general abuse of children. Instead, they were passed to limit the working hours and exploitation of young children who were paid a pittance for hard labour in mines, factories and industry. From this point onwards, many changes started to take place, such as society appreciating that children working for long hours in extreme conditions was contributing to a high mortality rate. Child protection societies and movements being formed and promoting the need for safeguarding them. Social perception, acknowledging that all children had a right to education and support regardless of their class or circumstance. A turning point in USA and UK child protection came in 1874 with the case of Mary Ellen from New York City. Due to the lack of laws defining child cruelty, the 10-year-old child was subjected to horrendous treatment by her guardians despite being under the charge of the local Department of Charities. This was the first documented child abuse case and directly led to the formation of the New York Society for the Prevention of Cruelty to Children. The influence of this case also led to the formation of similar agencies in the UK cities of Liverpool and London, which eventually became the National Society for the Prevention of Cruelty to Children, better known today as the NSPCC. After the first official Act of Parliament was passed in 1889, laws and reforms have been amended and updated to reflect high-profile cases and lessons that have been learnt. This was recently demonstrated with the sad case of Victoria Climby, an 8-year-old girl tortured and murdered by her great-aunt and her boyfriend in the UK. Her death in February 2000 led to major changes in child protection policies in the country, with the following deficiencies in the child protection system being noted. Major organisational and managerial failures in child protection services, responsibility and accountability for preventative measures were not clear, staff were under-resourced, poorly trained and lacked experience, communication and cooperation between departments and authorities was substandard. Amendments were made to UK legislation after the inquiry into the Victoria Climby case, which led to the Children Act 2004 superseding previous laws. Tragically, another incident near the same locality as that crime led to another child's death. Peter Connolly, who was anonymously known as Baby P during the police investigation, was a 17-month-old boy that died in 2007 as a result of horrific mistreatment by his mother, her partner and his brother. This led to further scrutiny of child protection services in the UK and further amendments. As such, the UK currently has a child protection system in place where each regional authority, department and agency plays an important part in contributing to safeguarding children. The system relies on these simple principles. National laws are passed to prevent acts of harm, abuse, exploitation or neglect from being committed on children by any individual. Guidelines are given to agencies and organisations to ensure they perform their duties for maintaining the safety of children. Reporting systems, communication links and appropriate information sharing are established between all those parties who safeguard children in any way. The foundational legislation for child protection has already been mentioned and is commonly known as the Children Act, officially known as the Children Act 2004. It is an amendment of the Children Act 1989, which was passed in light of the events of the Victoria Climby case. Ideally, the purpose of the Act is to make the country a safer place for children of all ages. It is crafted to encourage coordination between multiple official entities to support the well-being of children and provide for their basic needs. The main principles of the Children Act are as follows. The overall well-being of a child will always be the priority. Any delay to activities or investigation is considered to be detrimental to the welfare of a child. Court proceedings and related activities should only take place if they are beneficial to the child's well-being. Duty is placed on local authorities to be accountable for the delivery of regional child protection services. They must also cooperate in the promotion of a child's welfare, making arrangements to safeguard them at all times. Another important piece of UK legislation to know about is the Children and Social Work Act 2017. This was introduced to highlight other important factors that exist in the UK and contribute to a child's well-being. The Act includes guidance for ensuring that children are provided with adequate levels of education, given consideration when local authorities ensure the circumstances of a child's death are reviewed intensely, and that adoption and rehoming activities are controlled. Other legislation that needs to be referenced when safeguarding children includes the United Nations Convention on the Rights of the Child 1989. This is a multinational agreement signed by all UN members promising to protect children's rights. It explains who children are, all their rights, and the responsibilities of governments. Safeguarding Vulnerable Groups Act 2006. This was passed to prevent people who are deemed unsuitable to work with children and vulnerable adults from gaining access to them. Protection of Children Act 1978. This prevents inappropriate photographs or images of children from being taken or shared. Mental Capacity Act 2005. This is not usually associated with child safeguarding, but it is relevant to young people who are 16 and over who may not have the ability to make decisions for themselves. All organisations, agencies or services that work with children must have working policies that will guide their employees in their duties. This would cover such facilities as schools, nurseries, clinics and hospitals. It would also apply to public or private properties which would be naturally frequented by children and young people, such as swimming pools, retail stores and shopping centres. While some of these areas are not directly associated with safeguarding children, the workforce within them will need to know how to recognise abuse and how to interact with children themselves. Numerous government-backed guidelines and awareness programs have been introduced over recent years to ensure that companies and organisations have appropriate content on their safeguarding policies. These include keeping children safe in education. This is statutory guidance for schools and colleges on safeguarding children and safer recruitment, first published in 2015. Working together to safeguard children. This is statutory guidance on interagency working to safeguard and promote the welfare of children, also first published in 2015. Child abuse concerns, a guide for practitioners. This is guidance for employees that need to be able to identify and react to the signs of child abuse and neglect. This was also first published in 2015. Every Child Matters. This document and policy was first published in 2003, outlining activities for improving childcare. Some of these safeguarding policies principles depend on employee screening processes and background checks. For instance, it would be entirely inappropriate for a person to gain a role as a teaching assistant in a primary school if they had a criminal record that included child abuse cases. In the UK, National Record Services were merged in 2012 to create the Disclosure and Barring Service, otherwise known as the DBS. This was designed to enable organisations to make safer recruitment decisions by identifying candidates who may be unsuitable for work involving children or vulnerable adults, as well as providing other uses. Ultimately, the DBS should be used by all companies and departments that have any responsibility for safeguarding children or any vulnerable individuals. The service will fulfil 4 basic duties. It will assist employers in making sure that they don't hire unsuitable people who could potentially harm children. It will determine whether an individual should be added to